Let us, before we, however, start off today, let me acknowledge that we do meet on the Hmong people's traditional territory in which the university stands, and the Song is one of the Sage peoples whose historic relationship to this land continues to this day. And this reminder of the land we are on informs lots of things that we do here at the center. It is a matter of recognizing the colonial legacies that we face here and people face here on the west of Canada, and the responsibility as settlers we have to address those in our scholarly endeavors. With this, let me introduce Sokrand Han Phong Jun, who is a graduate student fellow at our center and also a PhD candidate at the Faculty of Law. And as you can see from Ken's CV, he works in the intersection of law and social movements. So, if I understand you correctly, your research, is your practice law in various forms, working also for an NGO in Thailand, and you're a driving force behind so that looking at environmental law and its application. But I think it is this tension between what the Constitution does as saying and what it looks like on the ground, something that lawyers might be familiar with, that the law is one thing, and sometimes a good abstract set of principles in the 97 Constitution in Thailand. And then what does it mean on the ground? How is law applied, and then what effects does it have? So in this respect here, I'm very curious to hear about your research, drawing on your expertise both as a lawyer in the field, working with social movements, and as now a PhD student in law. The floor is all yours, and curious to hear what you have to say.
First of all, thank you very much for the introduction. Thank you very much, everyone, to being here with me today. And first of all, I want to thank the center for allowing me to do work here, working on writing my research and interact with this cheerful group of academics. So it's my period. Today is my turn to tell my story. So the topic is the dynamics of law and movement in Thailand, a cycle of empowerment. So I might have problem. I cannot share screen. I mean that I will be doing that. Okay, let's go into the outline. So I will touch upon four topics here. First of all, I will talk a little about my motivation to study the relationship between law and movement. Second, I will move to the impact or benefit that social movement get from environmental rights. Then I move to talk about the factors that make law work for social movement. And the last part is my conclusion, where I look at the broad relationship between law and environmental rights movement. Okay, let's go. So today we travel from Victoria to the country located in Southeast Asia. I guess some of you may have been to Thailand before. The country located in Southeast Asia, surrounded by several countries. So if you travel there, you can travel to other countries easily. Actually, in terms of location, it's not that far from Victoria. So you can move to next slide. So it's the opposite side of the ocean. Right now, we have the direct flight from Vancouver. It takes 13 hours, right? So it's that is relationship.
Just around the corner.
Okay. Yeah.
Well, why would this go like straight line?
Yeah, it doesn't allow. So let's Google.
Go on the fly.
Okay. So let me get into the story. So first of all, I want to talk about the general idea of my research. My research examined the role of law in environmental movement in Thailand after the adoption of the 1997 Constitution. We recognize for the first time key environmental rights in our Constitution. My main research questions are first, what are the impacts of environmental rights on environmental rights movement? And second one is what factors contribute to effective legal strategy employed by these environmental movements. These two questions will help me to understand the relationship between various parties such as communities, lawyers, courts, NGOs, and government officials when law and rights are used to address environmental problems. So I have been involved in environmental movement in Thailand since I was a university student in 2001. It was 4 years after the adoption of the 1997 Constitution. So the atmosphere in university was very high. There was a lot of public events and public talk about the new Constitution. Society expectation of the Constitution was high. The idea of using Constitution to transform the country very high, and I was in that atmosphere and failed. I participated in one of several environmental student groups and changed my major from engineering to law because I want to be part of this movement. Like you can see the impact of the atmosphere. And I graduated in 2005 and began to work as public interest environmental lawyer at one organization for 10 years. At that period, I represented local community who suffer from various industrial pollution, community who protest against development projects that came to their community without their consent. In that period, I won some cases, lost some cases, maybe lost more than win. But what I haven't seen is, I haven't seen any real transformation as many people expected at the early year after the adoption of the Constitution. There were many people, including me as well. So my question is, what's wrong with Constitution? Environmental rights? Why didn't it transform our country to be better in dealing with environmental problems? Why did right revolution that many countries have experienced didn't happen in Thailand? With its background, I chose to study law and environmental rights movement and try to understand their relationship. So, okay. After 4 years of research, I will put my argument in first here. I have two main arguments. First, law play an important role in supporting environmental movement in Thailand after the adoption of the Constitution. The movement gained legal recognition from court, get various benefits that they never get before the adoption, and it made communities stronger. However, law has its own limitation. It doesn't solve many problems that environmental movement faced before the Constitution. Second, the new legal opportunity presented after the Constitution empower environmental movement to achieve what they had never achieved before. In turn, strong environmental movement make it possible for legal system to deliver unprecedented outcome in advancing environmental agenda. So the rest of the talk, I will back up this argument. So I will just introduce you about the idea of the 1997 Constitution that recognize the environmental rights. It's not isolated event, but it's part of what David Boyle called the environmental rights revolution. So in that period, a lot of countries, he documented about more than 140 countries recognize environmental rights or state responsibility to environment in their constitution. Thailand was one of these big trends. And this special constitution is important to Thai people because it was the first time it allowed public consultation throughout the country on the constitution drafting process. So there are a lot of mobilization before it's hard to be the constitution. So this is I already talked about, move to enacted. So what happened? First, it's clear that the recognition of individual rights give a lot of benefit to social movement when we look carefully. So I categorize the benefit into 3 groups. The first one is legal recognition. The second one is tangible benefit, and the third one is empowerment. So, rather than overwhelming you with a lot of interview and data, I will present 1 out of 6 case studies that I work on to demonstrate my point. So next, I will introduce you to my case study. It is about the pollution case affected indigenous people in Thailand. So we move to the west side of Thailand in community called Kritilang community. It located. This community is Karen indigenous community in Thailand. They have their own culture and their own language. This community located in one of the World Heritage Park in Kanchanaburi province, Western Thailand. This community has been relatively self-sufficient for generations. So they depend directly on natural resources from the forest and small river that flow to these villages. The river called Critic Creek. The Critic Creek supply villages both drinking water and water for household use and fish. And fish is important for them because they cannot afford buying meat and pork in the city. In 1967, the government granted a permit to mining company to construct and operate lead mine close to the Critic Creek. About 8 years, these villagers noticed change in the river. The water was smelty, muskier, and a lot of fish died. Initially, villagers responded to the change by adapting. So they store water when it's less musky. They avoid eating some part of fish. They also asked their leader to talk to mining company. However, nothing changed for many years. During this period, some villagers got sick and died mutilated. The animal that drank from the river got sick and died. Nobody knows for sure at that time what are the cause. But many people believe that the polluted river was the cause. So this is I went to the village twice. It's very far. From the closest city, it took you 4 hours. Next picture, please. This is religious ceremony last year. That they have their own culture that's different from other part of the country. So situation changed in 1997 when this community connected to NGO. An NGO brought recorder to village. Later, NGO connect villagers to lawyers. And these lawyers help them to include legal strategy into their movements. First, they frame their movement as environmental and community right violations. They use the 1997 Constitution as their reference. They filed 3 lawsuits against the mining company and the pollution control department, claiming that they violated their constitutional rights. So villagers asked court to order defendants to compensate them and clean up the river. So you may ask what happened after that. Are there any changes? So this is the river, only one water supply for them. So they both use for household and drink and fish. So next part I will talk about the impact of legal tool combining with various activities is not just litigation, but it is a part of their lawsuit movement. So first, I talk about legal recognition. Litigation leads to for affirmation and extension of intellectual rights. As I mentioned, Thailand first recognized intellectual rights in the 1997 Constitution. However, the Thai government and the mining company had avoided their responsibility to respect and comply with this right for years. Their behavior has changed only after PIELs witnessed 1 or 3 litigations in 2002, 2012, 2015, and 2017. After losing these cases, the pollution control department and the mining company began to compensate and start to clean up the creek. Just yet in these cases, agree with villagers that the constitution guarantees villagers the right to live in a healthy environment and benefit from natural resources. The mining company and the department, pollution control department, violated their rights and were responsible to compensate and clean up the creek. In other words, judges affirmed that environmental rights recognized in the Constitution must be respected. The environmental right, backed up by court order, put stall party to take action. In addition to affirming rights, litigation also led to court expansion of rights. For example, judges for the first time found that the pollution control department had a duty to clean up the polluted sea and order them to do so. In Thai history, they never cleaned up, happened before. Looking at this order from citizen perspective, the court is in fact extend the scope of right to a healthy environment to include right to force responsible party to fulfill their duty in restoring the polluted creek. So in some, legal tool brought about positive court judgments, but you may ask, did this case deliver any tangible benefit to communities? The answer is yes, it brought tangible benefit to community. The next part I will talk about tangible benefit. This is the picture of villager in court. So you can see their clothes, their dress differ from lawyer and people behind.
Where was this court? Which city?
In Bangkok.
In Bangkok.
This is administrative court. What are tangible benefits that villagers get from the court case? First, the court order the company to pay villagers about, in Thai, 119 million baht. So in Canadian term is about 4.8 million Canadian dollars. It is a huge of money for a small community of 300 residents. However, villagers have not received all of these compensation. At the end of 2022, they received 34 million baht, or about 1.4 million Canadian dollars, about 1/3 of what they entitled to. Still, this is a huge and large money that came into these communities. Second, litigation lead to the improvement of environmental quality. Only after losing the court case that the pollution control department began to systematically clean up the creek. The department spent about 18 million Canadian dollars to comply with the court order and committed to spend more $9 million in the next phase. This is almost impossible if the community didn't win the case, because the department long-standing position is that they want to let the river recover itself. So that's there. So the cleanup process also demonstrates a gradual improvement of the environment. The river has less contamination. Villagers have less lead in their blood. This is the result of the cleanup measure. However, at the end of 2022, the drinking water, the level of lead in the water is still high, and the water is not safe for drinking yet. So this fact remind us that in environmental cases, when pollution occurs, it is difficult to bring it back to the same level before the pollution happened. That's why the best way to deal with environmental issue is the precautionary principle. It also shows that legal means wouldn't solve any problem or problem. In sum, the legal strategy not only gives environmental movements legal recognition, but also tangible benefit. The court case also put the defendant to clean up the creeks, and they get some substantial money for the court case. So next, I will talk about the empowerment aspect. Next picture, please. You see this, this process of cleanup is quite a big deal. It's not small river, but when it need to clean up, they need to find another place to cover up these polluted sediments. Next, please. So the other benefit from legal strategy is community empowerment. Legal tools are newsworthy, and they help environmental movement in raising public awareness about that issue. And more public awareness means more pressure on responsible parties, right? So this is the testimony from research participants. They think media play a crucial role in their movement, and media really interested in litigation or legal process. And they stick with legal cases longer, more than 10 years, because the case finished about 10 to 13 years. And quickly, lead pollution case become one of the most well-known environmental cases in Thailand. Media has sustained their coverage on court for more than 10 years. And the popularity of it may be likely to raise public awareness. And this public awareness likely to make court and responsible party more responsive to the movement. So, next please. Not just only raising public awareness, but it also increased their negotiation power. Before the litigation, like you can see from their testimony, before lawsuit, government agency or company feel like they are nothing. You cannot do anything to us, right? You just, but after that, things change. You can see from the next picture. After the law court case, the man in the green t-shirt is the director of the pollution control department. When they lost case, they went to community. They set a meeting in their temple. This is the temple in their village. So they need to sit there to talk with villagers. It's almost impossible if there's no pressure for mitigation, because their stand is, just let nature recover itself. So, it's increased their negotiation power. Other aspect is it's inspire other communities. So legal strategy are new tool for environmental movement in Thailand. It's not usual. It is common that environmental movement would share their experiences with other communities. Legal strategy are part of these sharing. For instance, the pretty village become a site of where people go there to learn how can you include legal study into your movement overall. You can see it. People from northeastern Thailand travel to the village and learn from them. Not just only legal study, but other study as well. Next, please. And this is a picture of them in front of the Kanchanaburi Provincial Court. Next, please.
Yeah.
Okay, the last part is they change legal consciousness of people who are involved in the process. So both villagers and lawyers change their understanding about law after involving in this long process. Villagers change their understanding into in the past they see law as the means of state to control them. But after engaging the legal process and see the first hand that legal tool can help them achieve what they never achieved for 10 years. They see law in the more complicated way. It can be useful for them as well. As you see from the testimonies. Next, please. Yeah, this is the testimony from the lawyers. So I asked the lawyers, what do you consider as effective legal case? He said in the past, he focusing on setting legal precedent. But after working with this community for many years, he changed his mind. He said, currently we consider many aspects. First, we think about how we can help community or NGO foster their rights. Second, how community can use strategic litigation to support their movement. They can use the case to put forward their agenda without waiting for the final court judgment. This is change because in the past they focusing on setting precedent, but now they focus more on the process and empowerment. Next, please. This is another lawyer. He said, before this case, we lawyers did not think it was important to connect with community. We would communicate only with defendants and witnesses to prepare them for trial and ensure they were aligned with the law and fact we plan to use in our case. But after this, he said the focus is on empowering the community, not on court case. Next, please. And this is the testimony from NGO who work for 10 years with lawyers and communities. It said, this group of lawyers, public interest, environmental lawyers, differ from lawyers who represented us in previous cases. They consulted us, allowed us to tell our story, and were concerned about our thinking. They did not concern only about fact, but also how our opinion and why situation happened. So it's not just winning court case. It's about your story and how they try to address their problem. Next, please. So I move to next part. We want to talk about what make law work for environmental movements. So I identify 3 factors that contribute to the effectiveness of legal strategy. Third, the presence of new legal opportunity following the 1997 Constitution is quite clear from the fieldwork and from court case that the presence of environmental rights, administrative court, and human rights agency help these environmental movement to achieve what they never achieved before. For without the right recognition, is almost impossible for them to use this right to frame their movement in terms of constitutional right violation rather than just environmental problem, which is happen all the time in our country. Next, please. Second, the present of public interest, environmental lawyers and NGO play a crucial role in helping community to take advantage of the new legal opportunities. So these environmental rights, administrative court, and human rights commission is not work automatically. No, it's be there. And it's very difficult for villagers who live far away from the city to know how it works, to understand how it works, and to make use of it. NGO and environmental lawyer make it possible to support the villager to understand legal and to help them navigate these complicated legal processes, and also support funding. This is important. It's not easy for people to use court or legal process. First of all, it takes a lot of money, and without support from NGO and public interest environmental lawyer, it's almost impossible for them to afford legal tools. Next, please. However, the engagement of community is also the most important in these factors to make legal work. So without community engagement, it's almost impossible to put forward legal strategy. First of all, they are the one who decided to include legal strategy into their movement. If they say no, it's not happening, right? Second, they are not relying solely on litigation, but along the way, they need to complement legal strategy with campaigns, press release, and also protest. So these together makes community engagements very important for environmental rights movement. Next, please. Yeah, and it is important that in Thai context, it's not uncommon when villagers file a lawsuit against government or company that they get lawsuit back, or even physical threat. So if they are not stick together, it's really difficult to put forward legal strategy until the end. So last, I want to move to my conclusion. What I see from my research, my observation about the relationship between environmental rights and environmental movement, I found that the presence of the new legal opportunity, including environmental rights board and human rights agencies, it made it possible for environmental movement to mobilize their movements, to frame it into constitutional right violation, and to use it to support their movement. It's impossible for them to frame it like it or to mobilize like it before the adoption of the constitution. But at the same time, from the legal system perspective, before the 1997 constitution, law play very little role in environmental rights movement rather than regulating the movement. But after the 1997 constitution and strong push by environmental movement, law and court play an important role to support the movement. For example, they set very expansive legal precedent, like bring pollution play principle into the jurisprudence and put forward a lot of environmental rights agenda that the government reluctant to push. So in this sense, environmental movement also empower the legal system to do what they never ever do before. So with that, I will stop my talk now. I welcome your comment, your question there. Yeah. Thank you very much.
Fascinating investigation of intersection of social movements and state institutions and the legal system and pursuit of environmental issues. thank you for using us to the Thai context. I'm sure it resonates with many of you here in the room. Think about how to make it all work. That's be a tall order, but an important one, particularly when it comes to the environment. But also for those of you graduate students here, it's fascinating to see how a passion for a particular issue, political cause, can lead you to excellent research and scholarship, right? And so what we see here is the intersection between activism on the one hand, and then the systematic investigation cases that we've just seen. Who wants to start it off with a question?
Thank you. It was interesting. I have a question about what you mean exactly by environmental rights, right? Because the agreement described with this kind is basically a case of badly defined property rights. And most cases of negative externalities like pollution is happen because certain type of property rights are either unenforced or badly defined. And the former case is very much the case here. What the law court said to this company was, this river is not yours to pollute, right? So from now on, you have to start paying compensation. But you haven't started enforcing rights of the environment. You're enforcing rights of the individuals who live in this environment, right? So how exactly, how would this fall within the environmental rights category? Because you're not giving rights to the environment. Right? You're not saying you should stop polluting because this river or the animals who live in it or whatever have rights. You stop polluting or you ask for compensation because you have harmed basically the human beings or the citizens who are living there. And so this actually resonates with what that's talking about legal philosophy, where the environment can have rights at all. So yeah, let's talk. This.
Thank you for the question. Yeah, I would say the individual rights in my dissertation, what I mean is the right to live in a healthy environment. So in that sense, you are right, it's right of individual. But the right of individual to be in the healthy environment. So in this sense, the river is the common. It's not the people property, right? But when it's affected by the company, so the Thai Constitution for the first time recognized right to live in a healthy environment. And when the company polluted the river that infected villagers, even this is not their property, villagers have right to claim the compensation. And the court recognized that is the right that the Constitution recognized, and when it violates the law, the court have power to force responsible party to compensate to villagers. So that's and it's not right. You mentioned it's not the right of nature. I consider haven't recognized the right of nature yet.
Okay, yes, so imagine a situation where you have a legal document that states that this river is the property of that community. Right? The pollution would have never happened because the company wouldn't have been allowed to, dump the waste inside the river. Right? Or you have basically to pay for the rights to do so. Right? There's like you can buy rights to pollute. You kind of like there are like particular markets that you can create for neighbors and so on. Right? And so the best way to protect the environment is to ascribe this piece of environment to that individual or to that community. Right? So it's not just like, you have a right to live in a healthy environment, you just have a right to own that piece of land or that particular river and so on. And if they want to allow others to pollute it in exchange of compensation, that's their right. If they want to prevent that company from polluting, that's also their right. But you're still not, you're just giving property, just ascribing the property rights to an individual or to a community, not giving rights to the environment. That's
so I see your point. Yet the point is our legal system, the Constitution didn't give us right to in terms of property rights. So it still be common property right now, right?
Yeah, but that's the problem, right? So that's my point. That's the problem. The reason the company was allowed, felt it had the right to pollute because this is common stuff, right? I can just pollute it because anyway, this is no one's river. This belongs to no one, right? If it did belong to someone, then the company wouldn't have done that. You see what I mean?
Yeah,
that's precisely.
Thank you.
Well, maybe someone else will have a better point. We're having a little bit of a discussion. So there are two interesting things. Yes, talking about environmental rights can mean two different things. It can mean giving a river or a mountain rights, which has happened in a few places. But in more parts of the world, it actually means what he's talking about, giving, acknowledging a right to live in a healthy environment. We're having something of a discussion of this in Canada. One of the reasons that this is different from just recognizing property rights is that it takes it out of tort law. And it means that people don't have to sue, and they don't have to show they've been individually damaged, which, is your point, they didn't own the river, whether they did or not. If it's a matter of tort law, you have to show damages. If it's a constitutional right, it's a whole different matter, and it can be much easier for communities to make certain kinds of claims. They still have to do the legal process, it's still expensive, and I'm very interested in the administrative court aspect, which, if we recognize this right in Canada, we would not automatically have anything. I mean, the real work is always in the regulations that deliver on the law. But there is a significant difference why recognizing a constitutional right changes the legal environment in important ways. Maybe not always the best, but important ways. But I would like to hear more about the administrative court. Did that get set up at the time just of the Constitution?
Yes, actually it's the mandate of the 1997 Constitution to set up the new administrative court in Thailand.
Mhm.
The reason is because in the past, it really almost impossible for citizens to file a lawsuit against government officials and departments. So the Constitution mandate to set up the new court, and 3 years later they set up the new court. And these new courts, in terms of comparison to the previous court system, the Court of Justice is quite robust and quite progressive because there's no tradition to follow in that sense. So yeah, I think it's interesting and play a very important role in not just only criminal cases, but in other areas as well.
Thank you.
All the other mentally oriented folks in the room are like jumping in with questions. But so yeah, I'm actually I'm very interested in the point that both of you are making, and I'm going to just very briefly mention that so the Cochabamba People's Conference in 2010 sort of inaugurated this discussion of legal personhood for the earth, right? And then that's recently been extended into the Indian case for the I don't know the Indian name for the Naikai River in Quebec, and then there's another case of a river in New Zealand, and these rivers have been granted legal personhood. So, and I'm not a scholar, so I don't know how that differs, specifically in terms of the legal status vis-a-vis the rights argument that you're making. But I think that's important. That's a very important discussion rather. But I wanted to hear you say a little bit more about the indigenous communities, their own sort of understanding of their relationship, their relatedness, sort of shared embodiment, and or sort of like the way that the river is connected to their bodies, biochemically speaking, but also in terms of their responsibilities, obligations of care, and that sort of like that piece of it. And also just to understand, I was interested to hear you say that there was a discussion about sort of letting the river its own. I wanted to hear you say more about sort of how they imagine, what would their responsibility or sort of burden of care had been if there had not been lead pollution, and then what does it look like, now? Like, do they sort of, are there active steps that they are taking in terms of sort of, let's say, traditional medicinal use of, relationship with the land, care for the forest, certain tending practices, I don't know, compost, this kind of thing. Like, are there those kinds of things that became part of the conversation or that you learned about from working on this case? That might be a little bit too deep, but I'm just curious about what you touched on.
Thank you very much.
Yeah.
I will deal with the second question first.
Sure.
Because it's quite controversial. Actually, the government did some research and found that it's gonna cost a lot of money to clean up the river, and they compare the impact to these 300 residents with this huge of money, and they found out that maybe the best way is what they call let the nature recover itself. But the problem that many economic challenges is that how long it's gonna take. how long it can take and how the villager will live in this area. They cannot answer this question, right? So it's not much about technology, but it's about cost benefit analysis that bring them to that conclusion, right? So after the last court case, that's why they start to do deep research, and actually it turned out it's cost a lot of money. And you see about 30 million Canadian dollars to clean up, and it's not guaranteed that the river will come back to before pollution, right? But it shows some progress, gradual progress after the measure was taken. So about the relationship with river is connected, right? So this case is very interesting because actually when lawyer came to their witness, what they ask lawyer to do is that they want their river back. They don't mention money at all. Compensation is nothing that they care about. They want the river back because their life related to this river. So they want this back, and they fought very hard with lawyers. They can concede to compensation. They can just disregard compensation, but one thing they don't compromise is cleaning up the river. So I think that show how they see this relationship between themselves and the river. Is not like thing, but it's like their part of their community, something like that.
Thank you, that's a superb presentation, and I'm going to pivot us away from the rights of nature versus centric. Even though it's a great conversation, I think that's kind of like a separate conversation to be had. There's lots of to be discussed about what the Canadian version is versus New Zealand, etc. But I think I'm going to try and touch on what the core of your research is, which I think is sort of like this classic age-old. I mean, I had it, and I'm embarrassed to admit it, 25 years ago when I was in law school. This question, is law important, right? Does law matter? Is it that the social movement is happening and law just reflects the social movement? Or is it that law actually can lead? Law sets in motion a social movement. And I think, and I suspect you are already answering, it's a bit of both. I think sadly, from my experience in the Canadian context, and you could probably quibble around the charter as one difference, but I think it actually set in motion something new and innovative that people didn't realize at the time. But in most cases, certainly in the environment that I've seen, the law chases. It is so far behind that it's actually often almost problematic. I wouldn't ever admit this in front of a funder or anybody's program, but sometimes it's almost a waste of time and energy. Except, as you are kind of indicating, and I think that's a great case study, when you talk about its power, society, perception, to create like a catalyst to bring people's attention and focus. If I have a media statement, nobody's interested. But if I'm part of a court case where I'm going to sue somebody or seek damages, suddenly there's a lot of media. So you can use it as a much more tactical tool than a legal tool. Am I right in understanding that that's what you're trying to tease apart? And maybe I can push you a little bit and say, you've been studying this, you've been living it what's your conclusion? Is it more that law is useful to drive emotion, or is it a tactical tool? And if we can accept that, we actually have to train our lawyers very differently. We have to train them to be network builders, to be capacity builders, to be good spokespeople, to train people in place and community in place. The nitty-gritty details of the admin law in section 37 sub 3 CB and its interpretation become sort of like almost performative. I never admit that even in law school. They run me right out of town. But It's a fascinating question, because I've actually been thinking about this for about 25 years.
Thank you for this interesting and provoking idea. Yeah, I would say if you consider this 1997 constitution, actually it started social movement. So they pushed forward to recognizing individual rights. But what they haven't imagined is that they think when they have right at that time, it can work. So they don't think in terms of how to implement those rights or how to make rights empower society. So that's what I find interesting, that when social movement put forward this new right agenda, they don't usually follow up because they think they're done with this, with their work. But from the work I find is far from done. It's just the beginning. And after that, it's more interesting and more important. If they don't keep pushing, that right gonna be dormant, and it will not useful to any social movement. So in that sense, I may agree. I agree with you that social movement is more important than law, but at the same time, law is the powerful tool for social movement to mobilize around that. So I think when we train lawyers, we need to expand their understanding beyond just setting legal precedent, but to see the power that they can give to society along the way of legal process. So from the beginning to the end, between is maybe more important than the end of court judgment. As one lawyer commented in my interview, is even in the case that they lost, they can get a lot of benefits from the court case because they can empower society, and then the mark for moving forward. Like if this law it doesn't work, we may need new right recognition into our law or right, and then put forward from that. Yeah, that's my response.
And so maybe just you just humor me for 30 more seconds. You know, it has to be one of the interesting developments of what's happened in the law school here, right? So the development of the environmental law clinic, right? The environmental law clinic, when I was a law student, learning about the never-ending list of laws and all the little applications and things. And we actually back then kind of almost thought I could almost know them all. But there's this moment where you get this kind of like explosion of exponential growth. And you actually can't know them all anymore, so nobody even thinks that anymore. But they actually pivoted the program to actually train people to do press releases and write off ads and have real client experiences that aren't just about gathering the context of a case, preparing people to be good witnesses, but instead to think about, well, how do they relate to their partners? How are you going to engage your indigenous neighbors? How are you going to, advance a broader suite of things and use legal tools to inform peace? And you can see the same thing happening now in the context of the indigenous law program. And so I guess I just wonder, from your perspective, what would be your advice to this next generation of lawyers? Because they have to still be good lawyers, but they also have to do all this other stuff. What's the limit? What would you really emphasize? What, from this lesson, you've had a wonderful career. How would you bring it to the next level?
I would say we need the mobilization skill, and we need other skills like how to communicate, not in the past, a lot of people focusing on communicate with the judge or your client. But what I see that we need to teach them skill to communicate with the public, with community or with the space, so they can use their legal skill in different field, not just only in court, but they still need very solid legal skill in that sense. Yeah.
Maybe before we start reforming law program. That definitely sounds more interesting than my time, but I would have probably taken more. Let us go to Rosie's. Thank you for joining us today. And let me read your question here. She asks, are the environmental movements connected in any way to international environmental NGOs? And do you know how the movements are funded? So, the mechanics of bringing this to the attention of the Thai public and the legal system. So is there, a kind of international connection here? And the other one is pragmatic, and Jenny, you touched a bit on it, and you had it in your slides as well. So the mechanics of being able to bring something to court, right? You need the funding, you need the expertise, all those, and clearly these are pretty marginalized communities.
Yes. Yes, these movements have connected to some national environmental organization and also international organization. For example, Greenpeace also involved in this case, so they support the campaigns. So it's not isolated movement. And yeah, for example, Human Rights Watch also go to the internet and report very interesting and do the documentary that support the community. So there are the connection between local movement and national and international movement, especially in these pretty big pollution case. Yeah, and as I mentioned, the funding is very important part of the especially for this community. I can say for sure that it's almost impossible for them to hire lawyers. Impossible because of what? Because they depend very less on money. Actually, they are sufficient community. They use money, but less use money. And when you hire a lawyer, you need a lot of money, right? And they don't just need lawyer; they need specialized lawyer, individual lawyer. That is premium fee, right? So in this sense, almost impossible for them to get into these lawyers. The funding so is very important. And when we think about law reform, we don't think about funding to support the community to use legal tool, right? We think it's by their own. And maybe it works in developed countries, right? Canada or the US. When you have good law, people maybe are able to use. But it doesn't work in Thai context where people are not able to afford that's money, extra money to hire a lawyer. So that's why in the first step they adapted to the environment to just store water when it's not messy. It's really very sad for us when we heard about it. Very sad because they're slowly water supply and they have no choice. Just try to store it with not massive because it's very difficult for them to get the support. So the NGO and lawyer play a good role to make it possible for them to use the legal tool.
I look forward to talking on that. Where is this company's head office based?
This interesting.
This particular company,
This is local company.
it is okay.
Yeah, local company. And it's
The
one.
mining companies.
Yeah, the local.
You can see the strategists already thinking.
Well, no, I think it's, we may not know, but most of these companies will be registered in Canada.
Right.
Because Canada is perceived around the world as a civilized place with constitution and world law. And then we go and we let people have their way out elsewhere, and we have not set up systems in Canada to hold our companies accountable. That's not in this case, so I'll leave that. But I speak as a former foreign labeled foreign funder of environmental radicals. I'm probably wearing that legacy on my shirt, actually. There is tremendous effort to discredit any people, any funders and NGOs, and every step along the way that would give power to people who are meant to be powerless in these kind of situations. One thing we find they often do is they will, in a situation like that, the opposing forces will actually go in and spread division within the community and make it very hard for those community leaders who are using the legal line to do that in the communities, they feel like they're told. There's a narrative is built up, a counter narrative is built up that says they're actually out to destroy the jobs of their neighbors who are lead miners, for example, and so on. I was wondering, did that play out in your situation? Did that kind of divisiveness where there forces in trying to divide the communities as well over this issue?
In some extent, yes, but it's quite lucky that the mining location is like 12 kilometers far away from the village.
Yeah.
So there are another village who get benefit from this
I know.
mining, but not the village that impacted by the mining company. So for this pretty land community, they got only impact. They didn't get any benefit from the mining company at all. So that's why I think one reason they could stick together for 30, 40 years to fighting this company.
Interesting.
Yeah, they try to divide and control, but it doesn't work out because the community didn't get any benefit from this mining company.
Helpful.
We will update our website with you with title then.
Good question, actually, that I might have answered in your presentation and I might have missed it. But I think that I picked up on this correctly, that the government has made this decision to let the river recover itself rather than paying to clean it up. But you also talked about the company being responsible. So I'm wondering why it is that the government is sort of responsible for the cleanup when I don't know what the relationship is between that payment. And part of the reason that it's curious to me is also because we know, of course, in many places that there's a history of, making land and an environment untenable for people to live on, so that you get that cultural loss over time. And you sort of remove that community's connection with the land if they can't use it in that way over time. So I'm just wondering if there's any relationship there that I'm missing or don't understand.
Okay, yeah, this is very interesting question, and I think I didn't clear in my presentation. Actually, according to the pollution pay principle, the one that's should responsible for the cleanup is supposed to be the mining company, right? So this is correct. Then who pollutes supposed to be cleaned up. The problem is the mining company rejected to clean up. Government rejected to clean up. Community filed a lawsuit almost at the same time against mining company in civil, and again the government to administrative court. The administrative court very active, delivered the first judgment and found that it is the duty of the state to clean up because you recognize their right to live in a healthy environment and you don't do your job to prevent it to happen. So they order the pollution control department to clean up first. And then the civil case come later. The court also ordered the mining company to responsible for the cleanup. So right now, two courts cooperate. It looks like the pollution control department start and spend money to clean up first, and they have power to take money to force money from this mining company. So it's like who did it, who responsible for the funding. So right now it's like both the government in charge of cleanup, but the mining company are responsible to pay the money that the government use to clean up. But the next question is, I don't think the government can get money from the mining company because of right now it's already bankrupt. and it already went about 30 years, 20 years, and the money that they already spent is too much for the individual or for the company that already bankrupt to recover. So in that sense, I think the public Thai people are the one who clean up these polluted river. It is, in one sense, it's not fair for the public. But if you think about the affected community, I think it's fair, because in some terms the government has responsibility to do that. When you recognize that right and you don't do your duty, yeah, you need to clean up. Yeah. Thank you.
So just to follow up on the other question about international stuff, do you know any other cases of international companies that it's similar, actually, like they're responsible for pollution? What would be, I guess, I mean, this is my ignorance, but I mean, what would be the recourse to the situations? And then I'm trying to think of also in other cases where governments like the US, for example, I believe had bases in Thailand, and of course, along with those bases usually came pollutants like Agent Orange and other sort of chemicals used. What would be, have there been cases that have been like levied against other governments for those similar issues of pollution? But there have been, international cases. International cases of pollution. What is usually the recourse?
In my sake of my case study, there is one case that involved a lot of international company, but in that case, community didn't ask for compensation. They asked for the cleanup measure, and they asked to the government, and the government are the one who try to find a way to get money from responsible company to clean up. So that's, and in Thailand, sure, there are a lot of cases that I did not include in my cases. For example, the big gold mining company that's operating in Thailand right now, and it impacts communities. The name is Kinggate. I think it's Australia company. Yeah, it's doing gold mining. So usually, yeah, their structure, they are international company, but they also set up the national company inside the country to, I don't know, because of their business model or to limit their liability, but they're going to be both. Yeah, the answer is yes. That the case that's international company are involved in pollutions.
Another question.
Yeah, I guess my question is more, perhaps a bit more local, or perhaps to get you to compare the Kitty Creek case with another one of the cases that you didn't mention. Because I'm just wondering about both the advantages and limitations of using this as so-called a model, which was, I think, on one of the slides that you mentioned just now. Because there would perhaps be, building on what everyone else has said, there were perhaps like some mechanisms of privilege and difference in the local history and context of environmental activism and engagement that might have led Kitty Creek to be able to achieve certain things. So I was just wondering about whether you have any views about the limitations in the Thai context of looking at this locale as some sort of a model. Yeah.
Okay. Yeah. In terms of the comparison, in SIG case study, the Kitty Creek case is the most effective case compared to other cases. So because it brings all benefit that I talked about, legal recognition, tangible benefit, and empowerment. And one thing stand out is that first thing, this community is got just only effect, not benefit from this mining company. The second one is that they have their own culture that really value these river compared to other cases that maybe impact their environment, but not the sense of that environment are part of their community. So in those cases, compensation may be enough, but then if it's cover their cost of living, like that. But in this case, they focus on recovering the river. So I think that's make this case more unique is their traditional or their indigenous communities, and they have special relationship with the river compared to other cases where they treat their property, right? Stand talks like the property. If you damage my property, you need to pay it back. Things like that. Yeah. Thank you.
Was this, very insightful and I think fascinating story that you told us. And I still remember when we first saw your application for fellowship, like, you will be able to talk to a lot of people here in the room. The evidence here today, many of the questions that you struggle with speak very much to some of your research here. The best of luck to both, your thesis, but also the fabulous work you do in the field. I understand you will continue being both, a scholar and an activist, and that's sometimes a tough way to straddle these two worlds, but really you have the energy and the expertise, to do this. So thank you very much for
Thank you.